Okay, unmuted.
Yeah, but they also, I can't see them online. I think that now we can have online quorums, right? Maybe not. There we go. Okay. Calling us back to order. We're on item C, discussion and possible action on motion for stay filed by the New Mexico Automotive Dealers Association in the matter of the petition to repeal existing rule 20.11.104 and MAC emission standards for new motor vehicles and adopt proposed replacement 2011-104 new motor vehicle emission standards. Albuquerque Air Quality Control Board petition 2023-1. And then I believe item D is the same motion first. It's the same, it's deciding on the same matter, whether or not to stay the repeal of 2011-104 and replace it with the new motor vehicle emission standards. If everyone consents, I would like to do these together. Doesn't make sense to me to do them twice. So if we can discuss what was filed by the Automotive Dealers Association as well as what was filed by Automundo de Garcia. And we'll start with just saying where we left this hanging at the last meeting to try to coordinate, this is my memory, so correct me, with EIB, Environmental Improvement Board. Last time we addressed this, when this rule was made, we did a joint hearing and both council and I reached out to council and to the chair. EIB responded that they scheduled their own hearing on a stay and we're looking into whether it could be a joint hearing. I know Mr. Domenici wants to talk on this item for his clients. If you can be brief, Mr. Domenici, and just limit to things that we haven't heard today or, already.
Thank you, Madam Chair. I have Mr. Ortiz's written comments. I'd like to present them for part of the record. So what you haven't really heard is the legal argument and the basis for a stay and what we are really requesting. So the idea of a stay of a decision is that there's an appeal pending. If the regulation or the decision takes effect and the appeal reverses that decision, has there been irreparable harm occur? So in order to evaluate that, a little bit needs to look into how long is the appeal going to take. So you can identify how much the regulation might affect before it's been heard on appeal. So this appeal, the docketing statement is going to be filed within the next week or 10 days. The Court of Appeals has to assign it to a calendar. The record has to be submitted. Then a briefing schedule is put in place, and it's pretty likely probably the briefing of this will be completed, all the briefing probably in about between 8 and 12 months. The last appeal, I just had an appellate decision come down, and that actually took 16 months from the final briefing to get that decision. So if we think that we might not get this brief for 10 months and then a 16-month decision, and that was pretty quick. I think that was on the quick side, 16 to 18 months. Then we're talking perhaps a Court of Appeals will decide if they're going to accept all or part of this rule in about 24 months, 24 to 28 months. The model year 2025 vehicles are arriving at dealers now. So the model year 2027 models will arrive 2 years from now, in the spring of 2026. So it is highly likely that manufacturers will be having to make the hard decisions of what they are going to do with respect to this regulation before the Court of Appeals has ruled on it. And what the manufacturers are required to do by law, if they're going to continue to sell in New Mexico, is deliver 43% electric vehicles to their new car dealers in New Mexico. So let's take it 24 months from now. We have a dealer, whether it's in Gallup or Albuquerque, and they receive 43% of their vehicles, if that's even possible from that manufacturer. They receive 43%. I think you heard this before, but I want to emphasize it. They sell the 57% of gasoline vehicles. The 43%, maybe 5% of that sells, and they can only get 5% or 5 or 6, the proportion of that 5 in new vehicles. So essentially, in gasoline vehicles. So essentially, their gasoline fleet sitting on their lot will be essentially exhausted within several months. They will, so we will have dealerships sitting with only electric vehicles throughout the state of New Mexico before this appeal is decided. And when those dealers are sitting with only electric vehicles, they will not be able to have employees. They will not be able to pay their debts, participate in their community. They will be irreparably harmed, with the possibility that the Court of Appeals will say, this is regulation, we're not going to adopt it, or we're not going to put all of it into effect. Particularly AC2 is really what we're focused on. So, and the irreparable harm doesn't stop with just the dealers. Then people looking for a new car will not be able to find one with their dealers. They will have to go out of state, or they will have to purchase used vehicles. So the used vehicle market will be affected. The used vehicle prices will go up. The out-of-state purchases are going to be costly to New Mexicans. And so the ripple effect will not be just the dealers and their employees and their infrastructure and their goodwill, but it will be the transportation security of New Mexicans will be affected, even though the regulation hasn't been blessed by the Court of Appeals. So what our showing is, we have to have a likelihood of success. We have to show good cause for a stay, and the stay requires a likelihood of success. That's been interpreted to basically mean that our appeal is not frivolous. Our appeal is not meritless. And just to go to the heart of, and you all heard the hearing, so I don't need to go through that again, but the criteria that are used by statute to have to be considered to adopt a regulation like this require looking into the economic practicability, the economic feasibility, and they also require, we feel, that the proper legal standards have been applied. And our position is, and our request today, which I want to very narrowly focus it, is that the Clean Cars 2 portion of the regulation clearly could have been considered separately by both boards. The way the regulation is drafted, it all references California law, but Clean Cars 2 is Title 13, Section 1962.2 through 0.8. That is the portion of Clean Cars 2 that is in the regulation. And that's all that we want stayed. That's referenced in subpart 104.102, C6 through 12. And then which incorporates those, just Clean Car 2. And then it's referenced again, those sections are sort of paraphrased in the regulations 104, 108 through 113. So we are only asking that the board stay the implementation of that portion of this regulation while the appeal is pending. The other portions of the regulation, which were explained to have significant benefits, we are not asking those be stayed. And we don't think they need to be stayed, and we think you can clearly separate out Clean Cars 2 from the advanced clean trucks and from the heavy low NOx omnibus portion of these regulations, and we're not asking that you touch those. I will say anecdotally, one of the first meetings I came to of this board, I saw a presentation on the precautionary principle from Member Lewis, and I think that bears in this situation. The exercise of some caution about the dramatic impact of this regulation, while it's pending on appeal, I think merits some consideration of caution and a stay. Because we're seeing the market is flat, the likelihood that a dealer will have any chance of selling 43% of electric vehicles in 2 years from now is virtually none. So something will happen. Either those manufacturers won't be providing vehicles to New Mexico, or they will, if they provide the first batch or two, they'll be sitting on parking lots and these dealers will not be able to function. And so I think we can show that we have a likelihood of success. I think when the evidence was presented and the arguments were made about Clean Cars 2 only, and the boards were advised, at least the EIB, and there was argument made by the Environment Department lawyers that you heard that you can't separate out the rule. Well, you can. When you adopt a rule, you're allowed to say we are going to adopt these sections and not these other ones. And we think the evidence, and we think the Court of Appeals will look favorably on the fact that the evidence for Clean Cars 2 doesn't meet the standards and doesn't satisfy the requirements, and that should have been a clear option for the boards. I remember even Mr. Eberlein's comments, and your all comments and deliberations were extremely short. We'd all waited for the EIB, but even Member Eberlein said, well, if we're going to get the benefits of heavy duty trucks and low NOx, then I don't see how we can oppose this regulation, because that's what he was led to believe. That was your only choice. Your choice was then and is now not to now it's to stay just the sections of Clean Car 2, which I just repeated. That's the sections 1962. And that was your choice at the hearing, and that's one of the issues that will be raised on appeal, along with a lot of other evidentiary issues that we think, frankly, in rulemaking has broad latitude, but speculation really isn't evidence, and we heard lots and lots of speculation. We've had not that much time since then, but we've had 4 or 5 months, and much of that speculative conjecture has not proven to be true. In fact, things have gone sideways or backwards on many of those. What the legislature passed was a maximum of a $3,000 rebate, and it actually reduces over time. As the regulation takes effect, the rebate reduces. So the first 2 years or so, it's $3,000, and then it goes down. The other issues to look at for good cause for you to consider is, are the interested parties going to be impacted? Well, the main interested party for this county is sitting over here, the Environmental Health Department. They take no position on this motion. They don't even oppose granting a stay. They're not going to stand up and speak against a stay. They are the main regulatory entity. NMED is different, but this body for this county, for this jurisdiction, doesn't feel strongly enough to even stand against this motion. So then you have the climate advocacy group. They filed a brief, very professional. They basically argued the merits of the case. They didn't really get into irreparable harm. They didn't try to rebut the irreparable harm that I'm describing. They pretty much argued you don't have a likelihood of success. And by the way, in two small paragraphs talk about irreparable harm, when we know that the intention of this regulation is to change the transportation future of New Mexicans. That's the intent. So just to argue it's not going to be irreparable kind of goes against the entire intent. The question is it going to be harmful during the time period before the Court of Appeals has a chance to hear it? And I think it's indisputable that it will be harmful. It's already harmful. It already is on the books. We are now labeled as a ZEV state. These manufacturers are having to consider how they're going to deal with us along with the other states. We are one of the smallest population bases. We have the largest, some of the largest traffic distances used by our vehicles. And but we're still in that group of ZEV states, which are mostly urban states on the coasts, with an exception or two, but not many. And we're being looked at by the manufacturers as what are we going to do with New Mexico? What will be available for New Mexicans in either electric or traditional gasoline powered vehicles? All that's up in the air, and that can be resolved with the stay. And then these manufacturers will know, well, we're going to know for sure if this regulation is the law in New Mexico. We will also have 2 years to see how the market functions, how the infrastructure is implemented, which is far too slow, frankly, to support 43% of market share. So from the manufacturers down to the dealers, to the customers, to the employees, to the pocketbooks of the state in terms of being able to sell new vehicles, there are many, many reasons we feel to stay this regulation, and it's within your authority. It's spelled out. The regulation says, in order to hear this, you shall appoint a hearing officer, which has not been done. But
sorry, we're just conferring because it seems like you're getting into a lot of the merits that would be in a hearing. So we're trying to.
Well, this is the hearing, as far as I know. There hasn't been another hearing scheduled. Right. And your next board meeting is April 10th. Yeah. Which is about 1 day or 2 days outside of the 60 days. I've got those numbers. So as far as I'm aware, unless something changes, but I'm happy to sit down.
There is a potential, as I stated earlier, and the board will start to discuss this. I don't know if it's likely, but EIB is holding a hearing. I don't know if they've scheduled it yet, but EIB is holding a hearing on a stay. What they do would affect us because it can only be one set of regulations. So we reached out to say maybe it should be joint, since we're supposed to make decisions for our jurisdiction within Bernalillo County and Albuquerque, and they're supposed to make jurisdictions for outside of that jurisdiction and outside of tribal lands. And so, yeah, it's starting to get a little confused in my head because if this would be what you were talking about in that hearing.
The EIB, well, I don't know if there's another hearing with you, or you're going to make a decision tonight, but the EIB hearing is March 22nd, 9 a.m. They have a scheduling order. Felicia Orth there's an order appointing her, your same hearing officer. Scheduling order requiring pre-filed direct testimony with time limitations. There's limits on argument, and there's a rebuttal time period. The testimonies due this Friday from the movement, and then the rebuttals due next Wednesday. So just to inform you about how that has been scheduled. I can tell you in the EIB hearing and the scheduling hearing with the hearing officer, there was no discussion of a joint hearing. So there was nothing to lead anyone participating to believe that they were considering a joint hearing. They might have been, but it did not come up from the board's counsel, or Felicia Orth at the scheduling hearing with the parties involved.
Yeah. I'm going to just cut you off because I think that the fact that hearing exists means that there will be a hearing on the stay. Whether or not we get to participate in it is something we have to decide.
On the same line, what do you think happens if they vote yes on the stay and we vote no, or we don't vote? Does the stay granted?
Yes.
I doubt it, because we made a decision with both boards. I think both boards have to participate and rule on the same issue. If there's a split issue, I think you have no resolution.
Well, I disagree, because I think the state, there has to be a uniform rule for the state. And if one board stays it, at least our position would be.
Well, again, that's probably something the Court of Appeals should probably rule on. But the second issue I'd like to ask you, and I don't know if this is out of turn or not, is appeal was filed immediately after the rule. And normally in litigation, a filing of appeal makes the lower court lose jurisdiction. Do we have jurisdiction to make us, to do it, to give you a stay?
Absolutely. The statute requires, specifically states you have jurisdiction. I'll read you the
Okay,
statute.
read it, please.
So this is
2011-82-35.
well, that's the regulation. This is the statute. 74-2-9, judicial review. Any person adversely affected by the administrative action taken by the Environment Improvement Board or the local board may appeal to the Court of Appeals. So this sets up the appeal.
Yes.
The stay section reads, this is subpart D, after a hearing and a showing of good cause by the appellant, a stay of the action being appealed may be granted by the Environment Improvement Board or local board or the department or local agency, whichever took the action being appealed. So the statute actually requires us to go first to this board before we can even ask for a stay with the Court of Appeals. We have to go first. And your regulations have a requirement, have specific provisions for a stay. And the stay can be granted upon showing of good cause. And that good cause has been interpreted by case law to set up the four elements that I was going through. Likelihood.
But that section doesn't deal with the appeal. I mean, the timing of the appeal for that particular section.
Your regulations set forth that so the stay can be filed at any time.
Yeah, and I'm just asking these questions because if there are different interpretations by the two different boards, I think you are probably going to be required to seek a stay of the Court of Appeals, which is another option available to you.
We have to go through both boards first, or we wouldn't have standing to seek that stay that you're describing. So we have to do what we're doing.
Okay.
And then your regulations require that either you rule on a stay motion or it's deemed denied within 60 days. And so the 60 days runs out about April 8th, which is, so your next meeting is April 10th.
Right.
So unless you had a special meeting or somehow, scheduling issue, today was my understanding. We were prepared today. That's why we presented the public comment as testimony in support of the motion for stay.
Okay.
Thank you, Mr. Domenici. Discussion, we're going to open it up for board discussion. We can call him back up unless you have a question for him directly now or counsel.
Oh, while you're up there. So your argument makes sense to me. I'm following the line. I just want to confirm that I understand the argument, and maybe the gentleman, the dealers might want to speak about this, but the stay is needed. My understanding is because this process is going to be appealed, and if there is no stay, they sort of have to start getting ready to follow this new rule, even though there's a legal process that's still pending. Is that?
Exactly.
Okay.
That's exactly the point.
That makes complete sense to me. And then what you've just said answers my question, which is the way the legal process is set up, you have to come to us first to talk about a stay before going to a judge to request a stay. Is that correct?
The Court of Appeals, yes.
Court of Appeals,
Yeah,
okay.
that's correct.
Right. And so it sounds like one of the fundamental things we have to figure out is how we relate to what the state is doing.
That's within,
yeah.
I think Mr. Domenici may feel differently because he's arguing for a stay, whether it comes from us or from.
Oh, right. Yeah.
Right.
That's the
So
question. Like if we
our
say they
jurisdiction is our
don't,
question. Yeah.
there's some debate about that. But anyway, I understand the issues now. Thank you.
Great. Okay. Opening the floor up for discussion. I see Vice Chair Richard's hand is raised online.
Hi, thank you, Chair Paul. I just wanted to request some feedback from our council. It sounds like there are a couple of questions. One is whether, I guess one of my questions is there time for us to reach out to EIB and be a party to that hearing, thus making it a joint hearing, given all the public notification and other requirements legally that we would need to do? Would you be able to answer that, counsel?
If you wanted to join EIB, you'd probably have to set it up as a special meeting, which you do have time to do a special meeting, and to give the notice for a special meeting, if you wanted to do that. My understanding is from the attorney reached out to me. I didn't call him, and my understanding is he's going to argue that both boards need to act together, and I think it would eliminate confusion if both boards act together. I honestly believe it's confusing in the rules about whether you need to act together, and the orders don't specify that you're acting together. There were two separate orders and two separate votes and whatever. But I do believe that it wouldn't be a bad idea if you're going to consider a stay, to go ahead and do it with them. But if you're not going to consider a stay, and if you don't want to have a hearing, you could just let the time pass. So those are options you have. You have an option to hold an official hearing. I would say this was not the hearing, although Mr. Dominici would disagree, because it wasn't noticed as a hearing, and I don't believe that the other side thought that it was going to be a hearing, because what was said last time is that we were going to reach out, or that the board chair was going to reach out to EIB, which she did, and to figure out what was going on, since it was a joint matter. And I do believe that whatever one does is going to affect the other. So that's why I think it would be a nice idea if they were held together. If you're going to go forward with the hearing, you could choose not to go forward to the hearing because the rules allow you to just let the time lapse, and then it would be denied if that's what you choose to do. I mean, you have, like I said, you could let the time pass. You could seek to be part of the EIB hearing and do the notice for a special meeting. And that's what that would be, is because the stay is not like the rulemaking, so that it doesn't have to require publication in a newspaper and all of that. It's just another hearing of the board. And my calculations would be that the 90 days runs out April 9th for the last filed pleading, or the last filed motion for the stay. There was one filed that would run out April 7th, and another one that was filed April 9th. And so I think if you don't do something by April 9th, then it's deemed denied, and then they could go to the Court of Appeals.
And can I ask
And I honestly think they appealed early, because normally what you do is you wait for the final order, and this would be the final order, but they appealed immediately.
Okay, just one follow-up, and then I'll yield the floor. So in terms of if the time ran out and therefore a denial happened just because of the time, how would that impact and say EIB granted the stay? So you have two different outcomes by two different boards. What would be the outcome of that? How would that affect? Would then the party go to the appeals, or how does that work?
There would be two arguments in the Court of Appeals. One argument would be that by not having consistent regulations, the regulations fail. Another argument would be by acting alone without the board, that they acted beyond their authority. So all of these arguments would be heard in the Court of Appeals, would be what I would expect would happen.
Okay, and if we were to do a special meeting, when would we have to publicize that by? So it sounds like we'd have to get with EIB, coordinate that, and then publish it.
Yeah, it's the 72 hours and all of that.
Okay.
The normal things that you have to do for a special meeting.
Okay. There's nothing above and beyond that because it's a hearing in terms of
the hearing officer? Maybe I shouldn't.
No, there is already a hearing officer. What I would suggest you do is, and I know that they are going to argue, that EHD is going to argue that, or not EHD, I'm sorry, ED is going to argue that they should not be acting alone.
Okay. So Okay, so I'm just kind of trying to come up with a solution of like, when do, have a special meeting where we have a joint hearing with I'm sorry, not EHD, NMED to hear this. And I'm just wondering about the time.
That's one option you could do. I didn't ask, and I don't know if the chair asked whether they would allow you to participate in their hearing.
That's a small.
Yeah, so that's what I was going to address, Vice Chair Richards. So I reached out to the chair who hasn't gotten back to me on it. And so I think that's maybe the simplest course of action is to join their meeting, to have their hearing be a joint hearing, because then there isn't even a question of who made what decision, even though we still vote separately, and that's still, its own thing. Yeah, that's something that we could still do. I don't think that would be or it would act as are you saying, Counselor, they would act as a special meeting for us where we would give 72 hours notice, the hearing itself, and for them it would act just as it already is. If we were to join that meeting on the 22nd, if that's possible.
But that's assuming you want to go forward with the hearing. So the rules permit you to have a hearing if you're considering granting the stay, because you can't grant a stay without a hearing. They're silent about whether if you deny a stay, is a hearing required. It says, what the rules specifically say, and let me just, instead of relying on my memory, I'll look at the rules itself. It says, unless otherwise provided by governing law, which the board may grant a stay pending appeal of any regulatory change promulgated by the board. The board may only grant a stay if good cause is shown after a motion is filed and a hearing is held. So the motion has been filed. The hearing has not been held. And then it goes on to explain, the rule explains about getting a hearing officer and doing everything that EID, that's another example where our rules are exactly like EIB's. So, but you, at the last meeting, which I apologize, I was in and out of that meeting, but my understanding is that the last meeting you wanted to see what EIB was doing before you decided, and now you know what EIB is doing. So you can decide what you're going to do now, knowing what they're doing. But I would not consider this a hearing. It wasn't noticed as a hearing. The other side isn't participating. We did not get a hearing officer. So I would not personally consider this a hearing.
Vice Chair Richards, did that answer your question? Sorry.
Yes, thank you.
Okay, Member Galuski.
I do think we need to consider this request for a stay. I would not support just letting it evaporate by doing nothing. And I also think it's important to coordinate closely with the EIB because we were, for the obvious reasons we're discussing. So I guess the question is, can we organize that joint meeting? Can we make that happen? And can we make it happen on a time scale that makes sense? And
It's possible.
Is it possible? Does it have to be in person? Can it be, well, yeah, that gets the, but I guess the fundamental point is maybe do we need to make a decision about, are we going to take up the request versus letting it die on the vine?
Yeah, I think that's today's job. Our job today is to say, are we going to attempt, we can do three things. We can deny the motion or not decide on the motion, which have the same effect. So we're not going to hear a stay. We could say that we are going to have hear the stay in a joint hearing with the IB, or we could say we're going to hear it as our own board. That last one to me is troublesome for the same reason that they're doing it, but or not to say the opposite reason. I guess they're going ahead. I disagree with just going ahead without the same equivalency because it's deciding. Because I think that in effect, if we were to say, we agree, we have a hearing, we agree that there's been irreparable harm and this is what's done too fast. that stay would be for all the rules because the state has to have, we have to have the same rules as, actually, I'm not sure that this is fair. Council, maybe you can fill me in on that because as far as the final rule, yes, but I don't know if the stay, could you have two different, like a stay for one jurisdiction and not for one jurisdiction? Yeah.
I think, I personally believe that that would make the rules fail.
Yeah.
Because they have to be the same. This has to be statewide. The decision needs to be statewide.
Right.
So if one of you stays them, then they're not identical rules.
Yeah.
And not that they fail, but that they wouldn't go into effect as currently planned.
Okay, so
In other
those three options are still on the table.
Well, if you,
That was discussing the last one, which is just here having our own hearing separate from EIB on a stay, and I'm seeing, shaking heads on that. So now we have those two other options, trying to have a joint hearing. It's possible that we could have a joint hearing. It's possible that there would be issues and that they wouldn't
well,
come
I kind
together.
of think we need to reach out again to them to see where they stand. I mean, depending on what they say or not say, then that'll prompt us to go to the next step. If they are amenable to having a joint hearing with us, that'd be the best outcome, I think.
I agree with that, yeah.
If not, then I guess we have to have a plan B. And I don't think we have enough time to set up a hearing, get a hearing officer and do all that other stuff. So I think that's probably out of the question.
If I may ask another legal question about this.
Go ahead, Ben.
If the 90 days passes,
60.
or 60, whatever it is, and there's no action, then that motion for the stay is deemed to
Have been denied.
have been denied. And hopefully we wouldn't get to that point. Does that mean that there's no plausible way for them to request a stay again? Or
No, they would then go to the Court of Appeals and they would say,
Right.
on such and such a date, which I believe is April 9th, 60 days passed, therefore it was deemed to be denied. And so they'll have what they need to go to the Court of Appeals and ask for a stay there.
The second bite of the apple.
Right.
So they're not
without a recourse.
without any possibility for a
Right.
stay. In fact, we're only one element in this whole.
Can the Court of Appeals respond fairly quickly to a request for a stay?
They do and they do not.
That's just, okay.
It's conceivable that they could respond quickly, and it's also conceivable
Okay,
that
so it's a
they
gamble,
don't.
yeah.
It's Court of Appeals.
Well, I support the idea of us getting a joint meeting with the state.
Yeah.
That seems obvious to me, and what can we do? that?
Any thoughts, Member Eberline, on this?
Yeah, I agree with Mr. Galewski there, and Amir too. I think we need to try to get a joint hearing with EIB.
Okay,
Just
I
a
don't,
meeting, but a hearing.
so I'm gonna let Vice Chair Richards speak after this, but I only want to ask council about, I don't know that we can maybe we can vote to have one, but I don't know that we can ensure that one is had before then, right? Because that depends on them too. We can ensure that we have half of a joint hearing, but that's not a joint hearing. So, yeah, I'm just a little bit concerned about that vote. But let me ask, did you have a response to what I said legally?
That's correct. We can't the board can't force them to, but since they invited the board last time, I don't see why, it would be surprising to me if they said, no, we're just going to decide this without you. I would be surprised, but I can't guarantee that.
Well, that just booger up the whole thing. I mean, it's crazy because you have two different bodies making one decision. And I think the decision has to be uniform. If it's not uniform, then everything goes to pot.
I think it'll be confusing for the Court of Appeals as well.
Vice Chair Richards, you have your hand up?
Yeah, I just wanted to say that I feel a little uncomfortable making any decision because we only had one party represented, actually two, I guess. Mr. Domenici was representing two different parties, but we didn't have the climate advocates. And I did read their motion and it seemed like they had some interesting points as well. I'd just like to make a motion to reach out to request the chair reach out to the chair of the Environmental Improvement Board and request that a joint hearing on the stay, given that, and then also to request Felicia Orth as the hearing officer. And also as part of that motion to ensure that our public notification is appropriate for the joint hearing.
So, I like this idea, and I am concerned that it might not be possible because it is so soon, because they already have a meeting on the 22nd. So, I mean, we can do it, and we can vote to do it, and that's fine. I'm just saying that what might happen is I might reach out to Chair Sweeney, and then she will talk to people, and they will decide. And then if they decide, which we would hope to include us, it sounds like there's it's still unclear if that would meet our own meeting requirement. Go ahead.
Yes, the rules say that this is going to be decided at a meeting. So what you would be doing is scheduling the meeting at which you would decide it, so that it doesn't say, it's not a rulemaking in that sense. It's just a stay of a rulemaking that you already had. And the rules anticipate that decision would be made at a hearing. So I believe that you could give the 3-day notice of the hearing. Like, let's just hypothetically say you reached her tomorrow and she said, fine. And actually maybe Council Domenici could answer this question. Where is the hearing going to be located? Where is it going to happen?
It's where they usually hold their meeting in Santa Fe, or just at the Capitol.
At the Capitol?
They meet in one of the hearing rooms at the Capitol.
Oh, okay. That shouldn't be a problem, to find a space that's big enough.
Well, I think, the only thing we can do is try. And, we give it our best shot. If it works, it works. If it doesn't work, I mean, our hands are tied. We can't do anything else.
Well, the other thing you could do, which I know just to be clear, the other thing you could do is have your own hearing. Your own special meeting.
Well, I think that's physically impossible. I mean, one, for the notification, finding the room. I mean, it's way.
It would be easier and less confusing, I think, to have it with them.
Yes. I agree.
I totally agree with that, but I just wanted to make clear that it wasn't your only option.
Well, with the time constraints, I don't think. Yeah.
So we have a motion on the floor requesting that the chair reach out to EIB, requesting a joint hearing on the stay, and requesting Felicia Orth as the hearing officer, and ensuring public notification is appropriate on a stay of advanced clean car suit. Is there a second on that motion?
I second that.
Seconded by Member Galuski. So moved by Vice Chair Richard, seconded by Member Galuski. Any further discussion?
I'll just ask, do you want to put Plan B into this motion, or just, we know that the Plan B is you didn't act within 60 days, so it's deemed denied.
I don't think we need a motion to do nothing.
I like that. Good. Okay. So
I missed the
further
response
discussion. Oh,
from
Vice
Member
Chair.
Armijo. Can you repeat that?
You just said you don't need a.
It was a joke. You don't need a motion to do nothing.
Oh, okay. I thought maybe you added on to the motions.
Since
Okay.
this process will be taking place before the next meeting, that implies there are ways to communicate this.
Yeah, so I communicate with the chair of the IB.
Okay, great.
And I have I already reached out, as I said I would. I just didn't hear back from the IB yet. So I can't guarantee that won't happen again. And I just want to make sure that is clear, that I will do, if this is what we vote on, I will do what I can, but joint powers, right? Okay. So that motion is on the floor and seconded. If there's no further discussion, we can take a roll call vote. Ms. Esty Armijo, would you please call the roll?
Member Armijo,
Yes.
Member Kalman,
I think she's absent. Should have put her kids to bed.
it does not look like we have her online at the moment.
Yeah.
Member Eberline,
Yes.
Member Galuski,
Yes.
Vice Chair Richards,
Yes.
Chair Paul.
Yes. Motion passes, 5 yes, 1 absent, 0 no. Okay, I will do that. Okay, we can move on. So that was for item C and D. We can now move on to item E. Discussion possible action on draft order resolving the request to correct the regulation. Motion for correction of adopted rules in the matter of petition to amend Title 20, Chapter 11, Part 72 of New Mexico Administrative Code to require review and consideration of health, environment, and equity impacts. Okay, so we've heard from Mr. Domenici on this in public comment. Is there discussion from the board in terms of this motion?
Look, let me just,
I'm gonna,
I guess.
which one do you want first? Okay, Member Galuski and then Vice Chair Richards.
Okay, for this issue about correcting the regulation, I guess I just wanted to state that the text of the transcript where I'm quoted seems pretty clear. And it's probably hard to discuss the issues. It's hard for me to know how to discuss the issues about this request to correct the regulation without getting into the substantive issues, which I don't think we can really do because it becomes sort of a de facto rulemaking hearing. And so it's a little, I don't actually know what to propose to do, except that the text of the transcript seems very clear to me. I look at that and I don't have any ambiguity about what I asked, what you answered, and what I understood that to be. It's very clear to me.
I'm gonna do you want to respond directly to that or?
Well,
Okay, we'll do council and then Vice Chair Richards.
Yeah, do you want to go to the member?
Yeah, okay, Vice Chair Richards, please.
Hi, yes, I think what you understood, I think there was actually a misunderstanding. Member Lewis had mentioned the 1 mile radius of vulnerable communities. And then when I had added the back for those other chemicals, specific chemicals, there were 15, I believe. I did not intend that to be within the 1 mile. There's nothing in the transcript. I'm quoted on page 429 and page 430. There's nothing in there stating a 1 mile radius. So as the person who made the amendment, I did not intend that. And I want to point out, it was late in the evening. I think it was very, we were moving very quickly. And so it's understandable that there was a misunderstanding. But just as the individual who submitted that or requested that amendment, that was my intent. And so that being that, I'm sorry there was a misunderstanding. I came right after Member Lewis, who had talked about the 1 mile radius, so I can understand where that misunderstanding would have happened. There was really no pause between the two. I had just kind of continued with that. I think from what I understand from our council, that we really don't have jurisdiction to decide this, that it must go to the Court of Appeals. And I'd like to get council's opinion on that, because if that's the case, I feel like we should probably deny it if we don't have jurisdiction. So Council Cedillo.
This is not just an errata. This is a substantive change to what was passed. And what was passed was signed by the chair and the vice chair in a time period where it was ambiguous of whether I guess because the court has stayed the applicability of the rule, I guess you could argue that the board continued to exist. However, at the time, I did not believe that the board continued to exist because my understanding is that you comply with regulations until you get them reversed by the court. So it was normally when I'm asked to prepare a document, it's up to the person who signs it, normally the chair, to review it to make sure that I adequately captured what was going on. The time to have fixed this would have been the time when that first order that the board, that we drafted, that the board, that I drafted for the board, it had this in it. And there was no, well, again, that would have been complicated because the board didn't exist, but there was no motion to fix it. Nobody stood up to say that there was a problem. And that's why it carried through in the final rule, because this was in the first draft that the board passed as part of its statement of reasons. And then this was what was submitted with review, not only by the chair, but by the vice chair, because at the time, the vice chair was the senior ranking member of what was left of the board after that regulation 2388 or whatever it was, ordinance 2388 passed. So it was a very unusual situation. However, I think this is a substantive change, and a substantive change would require a rulemaking. So if the board felt like it wanted to make this substantive change, do another rulemaking. But right now, as it exists, I do not believe that you have authority, and I don't believe that the state records office is going to accept a substantive change. If there was a a number that was wrong, or some, a typo or something, that's one thing. But this is a substantive change to a rule that was passed and that was in the first, and I don't remember the date, but in the first order that was passed by the board and signed by the chair, and it was also submitted to the state records office as the official rule, and that was also signed by the chair and the vice chair. And so I just don't think you have authority to make that change. It's not it's a substantive change. Now, they can raise the issue in the Court of Appeals and say there wasn't substantial evidence justifying it and make the change or make that argument in the Court of Appeals. But I do not believe that you have the authority to make a substantive change without a complete rulemaking.
I agree.
And whether the intent, if the intent was different by other members, there's still the record.
Yeah, I agree. We'd probably have to have a whole nother hearing in order to do this, and I don't think we want to do that.
So what I did was I drafted an order, and I did not think that you were going to have a hearing tonight. The way I postured it was I drafted an order just documenting what you did last time. So if Mr. Armijo, if you would put this on the record so that everybody can see it, so the public can see it. So this order that I handed out to you, that it's draft 315-2024, it basically says that you've reviewed the motion, you discussed it.
Right, is this based on our conversation of the last meeting?
Yes, this is what, that you discussed it at the February 14th, 2024 meeting, that the board heard arguments on whether the board has authority to make corrections to the HEEI regulation, NMAC 20-11-72 et sec. I need to put et sec in there, which has been passed by the board during public hearing and published in the state register. The board concluded it had no authority to correct a published regulation if there was a correction to be made. Then this is what I understood happened. The board chair called on the board to make a motion on this issue. None were offered. Wherefore, the motion to correct EHEI regulation is denied because there was just no action taken. Now, that's what happened on the 14th. If you want to do something different, of course, and I should explain the reason I brought this order here for you all to consider is because normally the chair directs me to draft, could you draft
Our
an order?
decision on
Yeah,
anything, and I
on
did
a
not do
decision
that on
was
that day,
made.
yeah.
And there was nowhere that I could find in the tape, and I didn't hear it when I was there, any request to do an order. So so I didn't feel that it was appropriate not having authority to do an order of the decision because the chair hadn't asked me to. I thought it was appropriate to bring it to you because that's the normal,
Well, I
So-
suggest we go ahead and formalize this.
Yeah.
So we can say, okay, you.
I think it's a good idea.
So,
Unless there's further discussion, which there may be, I thought I saw Vice Chair Richards' hand up, then, we can either edit this or we can say, I can hear a motion either to deny or approve but I think deny what we're on, the motion for correction.
and the stated reasoning is correct. What I believe is correct. You don't have authority to correct a published, substantive.
Right, even if there were a correction to be made. I actually appreciate that language because it was a complicated hearing. Tonight there was some confusion there, and I think that had we not had a time limit, we may have made things a little less confusing for folks. So anyway, sorry.
I hear no motions.
Yeah. Can I have do we need a motion to deny it then, or can we just move to approve this?
You could approve this. I want to add EdSec to the 20-11-72. And then I noticed there's a period missing after. It's funny how you can see typos later, but there's a period missing. But again, this would be submitted to the chair and the chair would sign it, deciding whether it reflected what you want done, assuming you want this done. So it would be good to have a motion to adopt this order.
Vice Chair Richards, you put your hand down so you don't have a question now.
No, I was just going to make a motion.
Okay, I will hear your motion.
Okay, I make a motion to accept the order as written with the few corrections that Counselor Cedillo Lopez is making right now.
So at SEC on the line with the regulation, was there another correction?
Period.
A period after denied.
And a period after denied. Oh, I see it. Yeah, a period after denied on page 2. Wait, is there a second for that motion?
I second.
Okay, moved by Vice Chair Richards, seconded by Member Armijo. Any further discussion? Okay, Ms. Armijo, if you please call the roll.
Member Armijo,
Yes.
Member Kalman. Still absent. Member Eberline,
Yes.
Member Galuski,
Yes.
Vice Chair Richards,
Yes.
Chair Paul.
Yes. Motion passes 5 yeses, 1 absence, and 0 noes. Okay. So, yeah, now you can, council, please make those adjustments and prepare the order for my signature. We can have that formalized.
ma'am.
Thank you. Okay, we're now moving on to item F, our closed meeting. The board will go into a closed meeting with the board attorney to discuss and take possible action concerning litigation. That would be Albuquerque Bernalillo County Air Quality Control Board, Board of County Commissioners of Bernalillo County versus City of Albuquerque 202-CV-2-23-09295 and GCC Rio Grande et al. Versus Albuquerque Bernalillo County Air Quality Control Board, City of Albuquerque. D202-CV 2023-09435, an appeals of Clean Cars 2 regulations and the HEI regulation. After the closed meeting, the board will announce the scope of the discussion in the closed session and taking of any motions and votes based on closed session discussion. All right.
Chair Paul, before we pause, Ms. Este Armijo, will you be able to bring me into the closed session?
I can get her. You don't need to.
Okay.
We can do it by phone.
I'll call you.
Okay.
If I go home,
Remember Richard?
Remember Richardson, yeah. So we're going to now call our meeting back to order and announce I'll just announce the scope of our discussion. We spoke about the HEI appeal, the Clean Cars appeal, as well as the consolidation of various court cases involving the board, as well as those not involving the board, and next steps. And we discussed retaining Internet City of Lopez for Clean Cars for any appeals or further work on Clean Cars 2. So I think now it's time for me to ask for a motion for Internet City of Lopez to work on the appeal of Clean Cars 2.
I so move.
Okay, moved by member Armijo. Can I have a second?
A second.
Seconded by member Eberline. Any further discussion? Seeing none, Ms. Armijo, would you please call the roll?
Member Armijo,
Yes.
member Kalman,
Yes.
member Everline,
Yes.
member Galuski,
Yes.
Vice Chair Richards,
Yes.
Chair Paul. Chair Paul?
Sorry. Yes. Assuming the motion passes, I didn't get the count clearly.
Madam Chair, the vote is 6 yes, 0 no, and 0 absent.
Great,
I'll ask the city attorney
thank you.
about that.
And then we also discussed, in the closed session, continuing the approach that we had before where, because we have all this litigation going on, for leadership to be, who communicates with, council in the interim between meetings. Okay. Right, who can authorize the filings and, act on behalf of the board in between board meetings. Okay, so item 6 is our second public comment opportunity. I would remind people to do things, but I don't think we have anyone. Mrs. Armijo, do we have anyone?
We do.
Oh, we have someone. Okay, so I will read the script then. The next item of business for public comment, I'd like to name and affiliation for the record. We'll ask the commenters, please try to keep their remarks to no more than 5 minutes. If we have a bunch of folks, Mrs. Armijo, let's have the first public commenter.
We have Nicholas Maxwell.
We can. Thank you, Mr. Maxwell. Ms. Armijo, do you have any more folks signed up for public comment?
No, Madam Chair, we do not.
Okay. All right, so we can move on to item 7, other business. Is there any other business to discuss? We have, I think, future agenda items and committees. We haven't heard from our committees in a while. I understand folks have been busy, so I don't want to force them to explain the work they haven't done. Unless anyone would like to volunteer any information from committees, I'm going to assume none. Yeah. Okay, so future agenda items.
Chair Paul, I had one suggestion. Just wondering if we could ask EHD to kind of give us highlights on what they've done for mapping so far. Maybe that could be in their presentation, when they give us their presentation next month.
Great. I'm writing that down, EHD mapping on the leasing regulation. Perfect. If you put those words together in a different order, they make a sentence. Okay. Member Gluski. Oh, sorry. Okay. I think it sounds like there's maybe there was another report. No, but you guys can fill that in. We can rely on you.
The SO2 milestone report will be brief, very, very brief overview, and then the air board approval. So it'll include any, any comments that we get, we'll send to Westar, and then we'll run by the air board for final approval.
Okay. Oh yeah, and the last thing to say about the committees, to remind folks that, first of all, the committees haven't done anything in a while, but the committees were all made up of 2 members of the board who could communicate with the chair, so they never constituted a quorum, and that's why they're valid under the Open Meetings Act. I think there was a question about that. Okay, I think now that we've done our
I want to suggest that there'll probably be another closed meeting on litigation.
Yes, on the agenda. Yeah, so we've got 3 agenda items so far.
Yeah, including updates on the appeals.
Great. Anything else to discuss? All right. Item 8, adjournment. I will now adjourn the March 13th, 2024 Air Quality Control Board meeting at 8:47 p.m. Our next meeting is on the second Wednesday of April 10th at 5:30. Thank you all and have a good night.
Thank you.